All right, good morning.
Morning, Your Honor.
Welcome again to a Zoom session here at the Fifth District Court of Appeal. I'm Judge Harris, joined by Judges Pratt and Judge Wallace. Keep in mind, we are being recorded, live streamed on YouTube. If you have any electronic or other noise-making devices, please go ahead and silence those or shut them off at this time so that we are not interrupted. One case left on the docket today, 24-2016, I believe. Each side gets 20 minutes. Appellant, you can reserve as much of that as you would like for your rebuttal. By default, we'll set it at 5 minutes, but if you want anything other than that, please let us know and we'll certainly accommodate you. So at this time, Mr. Gilligan, sir, if you are ready, you may proceed.
Thank you, Your Honor. Patrick Gilligan for the plaintiffs, appellants, Chelsea Barker, Danica Bueno, and Alyssa Coffey. I would like to reserve 5 minutes, Your Honor. The trial court order, I did watch, by the way, via Zoom the prior argument, and I thought it was well done by both sides. The trial court order, I'd like to focus on a little bit different issue, at least initially. The court's questions in the prior hearing were substantively, I thought, to the substance of the factual issues going in the case. But I think the trial court order here starts off in error because the court didn't rely on Werner, which is the Fifth District Court of Appeals opinion about its latest version of interpretation of 768.72, and didn't even cite Werner, but in fact relied on the Permeter case, which I think the Supreme Court has taken up now out of the Fourth District. And those two cases are starkly, in my opinion, starkly at odds with each other. It seems to me that this court in Werner followed basically what the statute says, whereas I believe the Permeter court in the Fourth District conflates subparagraph 1 and subparagraph 2 of the punitive damages statute. And I think that's what our trial court judge did here, is he weighed the evidence and he decided whether there was clear and convincing evidence. I think that was improper at the trial court level because you can't really do that. You don't see the witnesses. Some of the evidence is a proffer of evidence. And subparagraph 2 of the statute clearly says if the trier of fact based on a clear and convincing evidence, which says the trier of fact in this case is going to be the jury. That's their duty, and the trial court here did that. Because of that reliance on Permeter, it allowed the trial court to make inferences where the inferences, if there were to be any inferences made, were to be made in favor of the plaintiffs in their motion to amend for punitive damages. Not only did he make inferences, he made inferences in favor of the defendants, which is clearly contrary to Werner. And it is clearly, I don't think, the clear language of the statute. Most troubling in the court's order, in his finding in his order denying the motion for punitive damages, is that he first starts out correctly citing the statute by saying the plaintiffs must show that Advent Health employees had actual knowledge that there was a high probability that injury or damage would result. That's from the statute, and if he'd stopped there, it would have been fine, but he did not. He goes on to say individuals with trauma react to trauma differently. Medical and medical health conditions, as well as past experiences, all play a part. No evidence has been proffered that the plaintiffs expressed or presented any vulnerabilities during their frequent meetings with and interactions with the respective preceptors and educators. Similarly, there's no evidence the plaintiffs shared any of their medical, mental health, or personal information that would alert Advent Health employees that would be vulnerable to an active shooter drill. And then he goes on to say the plaintiffs have not submitted evidence showing Advent Health and some actionable information that plaintiffs were at risk for the type of emotional injuries they're now claiming. We all learned in law school, I think in initial torts class, that you have to take the victims the way you find them. It's not the victims or the plaintiff's problem that they may or may not be mentally weaker than some other victim. That's not how it works. We all take them the way they're finding them. They had no duty and they had no obligation under the statute or Werner to put any evidence of their prior mental health condition in evidence. But the judge, by his order, clearly is suggesting that they did. And he's clearly suggesting that there's an inference in the fact that they did not do it. For whatever reason, the defendants in this case had not even deposed any of the plaintiffs, still haven't deposed any of the plaintiffs in this case. They have got some of their medical records, but they've not done any depositions of the plaintiffs. And so the judge, when you read his order, is inferring that somehow it was the duty of the plaintiffs to let Advent know that they shouldn't do an active shooter drill and not tell them about it and terrorize them because they had a pre-existing mental condition that would make them more susceptible to harm. There's no law in Florida that supports that. The defendant has not brought any of that case law to this court's attention. And I think that was one of the biggest issues in the case. One of the other inferences the court makes is he says that Miss Cook, who was Yolanda Cook, who was the supervisor of the two ladies, Hankinson and Torrens Nordine, had put on this active shooter drill, that although she was generally aware that the active shooter drill was going to take place and an Advent employee would portray the active shooter, she was not informed of any of the specific plans. The court in its order does not say what those specific plans were, but presumably what he meant was the specific plan not to tell the nurse trainees that they were going to be subjected to an active shooter drill where they were not told that the person portraying the active shooter was in fact an actor and not a real bad guy. That's contrary to the record. In the record, Ms. Hankinson says that she told Yolanda Cook about what they were doing. She doesn't elaborate on what it was, but the judge has made the inference, which is contrary to the statute, contrary to Werner, that somehow she wasn't told that, and therefore the defense was entitled to an inference. This was not proper. I did hear, and I do want to take up the issue of what Ms. Price said. On the record on appeal, the parties were provided with an organizational chart for the time of the incident in question. Now, the incident in question on that date, a gentleman by the name of Joe Johnson was the president and CEO of Advent Health. He had 6 different people directly reporting to him, one of them being Patricia Price, who's the chief of nursing operations. Ms. Price is one of 6 direct reports to the head guy at Advent. The other ones be chief financial officer, chief medical officer, people like that. She had reporting to her Kimberly Lukes, who's identified in the table of organization as a director. She also had Yolanda Cook, who's identified by their language as a director. And the statute says that it's managers, directors. So you're looking at their language. Judge Rogers, in his opinion, dismisses that, even though the language of the organizational charts makes clear who they are as directors, and the statute uses the word director. Now, whether or not they have the level of managerial authority is to be determined later, but the inference that should have been given to the plaintiffs in determining whether or not a motion for punitive damages was properly made under Werner was that, well, they called them that. They called them that. But we also have, and I want to take umbrage a little bit with the way it was reported that Ms. Price, who's, I say, at the second level of organization, talks about what happened. At her deposition, when she's questioned, but do you agree with the training that was done on November 30th, 2021? Answer, yes. And would you believe that Advent Hospital should continue to conduct that type of training? Answer, yes, including not people telling people it was a drill? Answer, yes. And having somebody brandishing what appeared to be a firearm and wearing a mask over their face? Answer, I was not aware of the mask. Okay, but now that you are, you would continue to advocate for that kind of training? Answer, yes. And make the students believe that they were in imminent peril? Answer, yes.
So
That's
Mr.
counsel,
Gilligan, doesn't that indicate that she has no managerial authority? If she would continue to do the exact same thing and the hospital hasn't done it, not even once since then, what authority does she have to manage that department?
It goes to the issue of ratifying and condoning, Your Honor, and the statute that she ratified and condoned it, and that imposes liability.
but isn't it true, counsel, that the hospital adopted after the after action report policies and procedures to prohibit this kind of training? Right. So, I mean, was her ratification, as you're framing it, you're saying that she ratified. I mean, how was her ratification even effective if the hospital has, for lack of a better word, gone, over her head and prohibited what she would otherwise have ratified had she had the authority to do it?
I dispute they did that, and I think counsel for the other plaintiffs disputed it too. I'm going to dispute it more forcefully. There was a memo that was apparently done by Ms. Laux that talks about maybe not doing this in the future because the nurses were upset. It wasn't an official pronouncement on high from Joe Johnson for sure. And when Ms. Price was deposed about that, she said she was unaware of this memo that Ms. Laux had written about that. I also dispute that because we have an affidavit in the record. We weren't allowed to take Joe Johnson's deposition with the defendants claiming the Apex doctrine, but he files an affidavit in this case that said he knew nothing about this. So that leaves a vacuum. So who and at what level is somebody in charge of making these managerial decisions? Ms. Price is saying we should go and do it in the future. Ms. Laux has said she's done some memo, but there's no official pronouncement of we're never going to do this again to this day. At least it's not in the record. Now, Joe Johnson is very much aware of the complaint. His hospital got sued. We asked other witnesses, does he know about the complaint? Was he sued? We're told, yes, he does. It has been very easy if we're going to rely on this, it only can be the head guy and the top guy. It would have been very easy for him to say, hey, now that I see this complaint, and now that I see what happened to 10 nurses, we're never going to do this again. And here's my memo saying it. We're done. That didn't happen. Joe Johnson is, I don't know anything, and therefore my corporate entity is immune from liability because I didn't know anything. Well, if he doesn't know anything and he doesn't correct the wrongfulness of something, he's condoning it by his own inaction. He's condoning it by his own lack of saying, we're not going to do this anymore. And that clearly has not happened. And I would add to it, if this level of managerial control is a two-way street, Your Honor. If Ms. Laux didn't have the level of managerial control to authorize doing this, why does she have the managerial control to say we're not going to do it? And if it's official policy of Advent Hospital, why is it not being put out as official pronouncement of the hospital itself, which it clearly has not been done? So I think.
Would you agree that your theory of corporate liability here rests on an interpretation of the punitive damages statute that allows for corporate liability after the fact? Essentially, that this concept of ratification can take place, after all of the events have already transpired, and it doesn't, necessarily require knowledge before or at the time of the alleged tort. Is that your understanding of the statute?
That's not my understanding of the statute, but it's not what we're contending. We're contending it certainly was ratified and condoned for the reasons I've articulated, but we think it was actually part and parcel of the planning, because in the testimony in the record itself, Ms. Nardines and Ms. Hankinson report that they told their supervisor, Yolanda Cook, about it. They told Miss Laux about it, and they told Mr. Debicki, who was head of the ER nurses in the emergency room, about it. So they told 3 different superiors in their chain of command about it, most particularly Yolanda Cook. And the argument I thought that I understood from my opponent was, well, they weren't involved in the planning. I don't know what planning is, except my commonsensical view of planning. I have people report to me at my job. I'm one of the senior lawyers here, and I'm a shareholder. So I have paralegals and receptionists and office managers. They come and talk to me about what they're doing. I don't know every last detail of what they're doing, but part of the overall planning process and management process is those people reporting to me and telling me what they're doing. That's what Miss Hankinson did. That's what Miss Nardines did. They reported to 3 separate superiors, or 1 superior and 2 people that are probably about their level. And they told them what they were doing. And so and because Joe Johnson to this day has never said, don't do that again. And Miss Laux is the only one that's saying we probably shouldn't do it in a memo, not as an official corporate policy, that the managerial authority to do this or not do this devolved down to the level of at least to Yolanda Cook. And when Miss Hankinson and Miss Nardine decided that they could do this, they had the tacit approval of Miss Yolanda Cook, who was identified as a director in the table of organizations. And I would also say that what this does, and Miss Caswick, I think correctly alluded to this, it creates a 2-tier system of justice where large corporations get immunity by just saying their top guy says, I don't know anything about that, which would probably be true for most large corporations. But my corporation, my PA, has 4 shareholders. We meet every Wednesday and talk about pretty much all the business of the business. We would never get away with that. And we did an active shooter drill and we did it. We wouldn't be able to claim that immunity, but only large corporations can claim immunity. And
Just so you know, Mr. Gilligan, you
okay, thank you, Ron. I'll stop now and come on back.
Okay, very good. All right, Ms. Downs.
Good morning again. Again, I represent Advent Health. And I'll try to save some time and get into the new things that were brought up during this argument, if that's okay. A couple of important distinctions here between the argument made by appellants here and what the law is and what the facts are. First of all, Ms. Cook, way down the corporate chart, and there are 2 that are in the record of this case. There were 2 that were before the trial court. Yolanda Cook is a director of a department. The statute says the officers, directors of the corporation. To suggest that the word director, as it's used within an organization, as the same thing as the owners and policymakers of the entire corporation, is without any authority in the law or in the statute. And as an aside, I understand the policy arguments. We might all make them if we were in the appellant's shoes. Those arguments need to be directed to the Florida legislature. And the legislature's speaking in 768.72 is not new law in some respects. The whole idea is you don't get tagged with punitive damages unless you have personal knowledge and direct involvement. And that's what the statute speaks to, what the policymakers of the organization do. The idea that Mr. Johnson, who was the first president, the first affidavit, it's now Ms. Skula, she said the same thing. All of this was before the trial court. By the way, the trial court gave the plaintiffs 2 years to develop their case. They did not deny any attempt to evidence. Both appellants have said to you today they were not allowed to take Mr. Johnson's deposition. That is not accurate, not supported by the record. We raised the apex doctrine, they dropped it. They never elected to take the deposition of the corporation. And so that takes us again to Ms. Price. Whatever her personal opinions are in support of her colleagues at a deposition or otherwise, they are not the policy decisions of this corporation. Maybe that's not why she's the president. So they could have taken Mr. Johnson's deposition had they gone to court to try it. They could have taken the corporation's deposition. We have 5 plaintiffs here. Any of them could have asked for the corporation's position on this. They would have said the after action report and plan, which is at 00198 at SEC. It goes on in detail. There's no qualification about it. The idea that the president has to bless it is also without support in the law. I also want to mention the reference to Werner. That was not an argument the trial court had the benefit of hearing from appellants, but that's okay.
Counsel,
This is a
I was going to say, I saw in the
Yes.
briefing this notion that failing to raise a case in the trial court means you can't raise it on appeal. I mean, that's not the law, right? I mean, you just have to
That
raise
is-
an argument, and if you don't cite every possible authority in support of that argument, that's our job, right? We can look at all of the authorities.
It is a de novo appeal. That's true. But the consequences of it is I get one brief. So I don't, get a chance to come back and respond to it. Werner was also not in the brief before this case. But I just want to say, no offense intended by any of the parties or certainly the trial court below. I think the Werner argument actually highlights that what we are duty bound to look at today is not the plaintiff's reactions, their fears, their fragility, or any of those things. All those things are important in real life and they're important in the lawsuit, but they are not important in this issue. The issue here is, what did the defendant intend? We only have one. It's a considered choice the plaintiffs made, and that defendant intended nothing by the action it knew nothing about. I also want to point out, and I would again refer the court, if the court wants to look at this issue in detail. I won't read all the testimony, but it can be found beginning in the record at 002105. It is undisputed that everyone north of the 2 nurse managers did not know the particulars. Some knew there would be a drill. Some knew that Travis Gilman, the supposed gunman, was going to help because someone had to approve his additional time spent. Nobody but the 2 nurse managers knew of the plan of this and what they did. And if there were any doubt, if there were any inferences that were going to flow, the moment Kim Laux found out about it, she reported to her superiors, who demanded an after action report. The investigation occurred. We've talked about that in detail. That after action report was put in place December 8, 2021, within about 20 days of the event, 25 days of the event, and a year before the lawsuit was brought. There is nothing in this record to suggest that was not the actual action of the corporation. I also want to mention this idea of 2-tier justice. Well, I have a small corporation too. It could also be that in my small corporation, someone could act without my knowledge in a way that was stupid, reckless, unforgivable. That doesn't mean, unless I know about in advance or affirmatively take some knowing, condoning ratification, I should be held responsible for that. Oh, I just want to talk forever, but I don't want to do that to all of you. Everybody's been respectful, so I'm going to sit down, so to speak, before my time and turn it back over to Mr. Gilligan. Thank you, Your Honor.
All right, thank you, counsel. Mr. Gilligan, 3.5 minutes.
Thank you, sir. I want to go to their intentions, and sometimes just look at people's words. What were their words? What did they intend to do? And immediately after the drill was over, Miss Hankinson says, it looks like we've traumatized them enough. After Mr. Gilman walked off, because he saw his testimony, he saw how it was affecting these nurses who were calling 911, calling their husbands, thinking about dying and never seeing their children again. They were traumatized. Miss Torrens Nordine in her deposition at least had the introspection to say that she would never do this again because she saw what it did to them that day.
But did she know ahead of time? Did she have knowledge that this would cause harm to these people?
I believe she did, and here's where I take here's where I go back to the judge's order, and then in the inference that he draws. He says that importantly, once the administrators of the drill recognized the effects went beyond what had been contemplated, the drill was terminated. He's factually wrong. These administrators did not terminate the drill. 10 minutes into it, Travis Gilman, who was holding the fake gun and they're dogpiled in the corner, Your Honor. They're not just standing there. They're on the floor in a huge heap of human beings stuck between the walls of cabinets. He sees what's happening to them. He chooses to walk off. And so it wasn't the administrators that did it. But let's concentrate on what the judge is saying here. Because if you had no intention from the get-go to harm people, but then let's take them at let's say they did. They just wanted to help them. You had no intention to harm them, but you then see for 10 minutes the harm that's happening, and you don't terminate that harm. What's that say? To me, the implication, and we are entitled to the implication of the inference. The inference is you intended it from the get-go. You cannot watch people dogpiled in the corner for 10 minutes. You cannot watch that. And you know that they're watching what they believe to be a real gunman, dogpiling them in the corner. You sit there, the two of them, and watch that. And you say initially, you didn't intend that. If you watch it for 10 minutes, doesn't matter. A jury may decide differently. But under Werner, under the statute, we're entitled to the inference that they did know. And 10 minutes of watching people being mentally tortured like that, thinking they're about to die, is that thing. And that's what we think the trial judge just didn't get here. Because he did the perimeter analysis. And maybe the Supreme Court will say that's right, but that's not the analysis before this court that this court has adopted. We're entitled to every inference. Not the defendants, and so that's what they did. And I'll just leave the court with this. Deputy Robbins said if he had arrived 2 to 3 minutes earlier and saw what was going on, it would have ended very badly, probably for Travis Gilman. So how much had to happen before it rises to the level of just totally outrageous conduct? Fortunately, nobody got shot, but that could have happened in this case. Thank you, Your Honor, for your applied attention.
All right. Again, thank you all very much. Well briefed and well argued case. We will be in recess. Have a great day.
Thank you.
Thank you.